Before we successfully led the campaign to enact the ASFA expanded discretion law, ASFA already had some wiggle room. There was already some discretion that foster care agencies could use to decide not to file termination of parental rights proceeding.
What this did is create an additional exception to the requirement that parental rights termination proceeding must be initiated any time a child has been in foster care for 15 out of the last 22 months. The existing federal exceptions were that the child is in the care of a relative, or that there's been a specific showing that it would not be in the child's best interests for the parental rights to be terminated.
The third exception is if there is a showing that the agency has not provided services to help the parent reunify.
What the expanded discretion law did was add an additional exception that said that when parents are incarcerated or in residential drug treatment, or where they have previously been incarcerated or in residential drug treatment, and that is a substantial reason that the child has remained in foster care, then the agencies are relieved of the requirement of filing a termination of parental rights proceeding.
Often in the past, this was part of the motivation for the law, caseworkers would think, oh, parent incarcerated equals adoption or equals filing for a termination for parental rights, and that's absolutely not the case at all.
Now, a very important provision of the expanded discretion law is this meaningful role requirement, because it requires the agencies to perform a thorough assessment of the parent's relationship with the children. Looking at all of the efforts that the parent has made, all of the ways in which the parent has maintained contact and tried to stay involved in the child's life, but also to talk to as many people as possible about the parent-child relationship, whether it be other relatives, attorneys, other participants in the court proceeding. One provision of the expanded discretion law relates to the requirement that agencies provide diligent efforts to parents to help them reunify with their children. And one of the requirements of the expanded discretion law is that the diligent efforts must include information to the parents about rehabilitative services, visiting plans, and other services that they can gain access to in order to reunify with their children, including services that might be available to them in the community after their release. Foster care agencies are required to provide incarcerated parents with a broad range of information about their rights and responsibilities so that they will be well informed of what their options are as well as what the legal requirements are. This is something that had not existed in prior law. An additional requirement of the expanded discretion law is the family services plan. This is a plan that's developed typically outside of the court proceedings in a separate administrative proceeding. Family services plans are now required to take into account the special circumstances of incarcerated parents, and also the incarcerated parents are required to be involved to the extent possible in developing the family services plan. It's important to stress that what the expanded discretion law does not do. First of all, it does not say that an agency may not terminate rights of an incarcerated parent. It expands discretion, it doesn't limit it. In addition, it doesn't change the grounds for termination. So in New York, one of the main grounds for termination of parental rights is permanent neglect. That requires an inquiry into whether the agencies maintain diligent efforts, but also whether the parent has maintained contact and planned for the future of the children. And there's a very important New York case that said that long-term incarceration and long-term placement of a child in foster care is not an acceptable plan, and that rights could be terminated for somebody who's serving a long prison sentence. The expanded discretion law didn't change any of that. It just says that the agencies are not required to move for termination, but they're still able to do so if those grounds exist. For family court judges, the expanded discretion law does several things. First of all, it gives them greater discretion because they're not under the strict time limit imposed by ASFA. They can take more time with a case, really evaluate the parent-child relationship when a parent is in prison. The expanded discretion law also gives the judges important new powers. They can order the agency to provide, to conduct a further assessment of the parent-child relationship. The agencies are required under the expanded discretion law to assess whether the parent is able to maintain a meaningful role in the child's life. And the law requires or provides the judges with the power to order the agencies to do that and to go back and do it more thoroughly if the judges aren't satisfied that they have all the information that's available to them. Finally, what the Act does is it creates some new duties. The judges are required to take into consideration the special circumstances that incarcerated parents face that may inhibit their ability to visit with their children, to maintain contact with their children, or possibly even to keep the agency informed of their whereabouts. And the courts are required to take this into consideration in determining whether a parent's rights should be terminated. But equally important, the expanded discretion law imposes some duties on judges, and in doing so creates an awareness for judges of exactly what the obstacles are for an incarcerated parent. A lot of judges, for example, don't realize that an incarcerated parent can only collect phone calls or can only get to a payphone during limited hours. And the expanded discretion law, by requiring the judges to take the particular constraints and particular circumstances of incarcerated parents into consideration, really requires the judges to inform themselves on what's possible and what's not possible for an incarcerated parent, and then to fashion orders accordingly that either take into account the constraints that the parents are facing, or try to overcome some of those constraints by ordering the child welfare agencies to take extra measures to make sure that the parent is fully involved in her or his child's case.
One of the challenges that I think incarcerated parents face is convincing the court and convincing everyone around them that their relationship with their children is as valuable as those parents who are not incarcerated and who are in the community. And one of the challenges is that, and I've heard judges say this, I'm not sending kids to prison. I'm not sending kids to jail. That's not an appropriate place for children to visit.
I can't emphasize enough the importance of visiting. It's sort of amazing that we even pose the question, because anyone who is a parent, and all of us were children, if we think about times that we were separated from our family, we wouldn't really question whether we would need to see the people who we love and who are closest to us.
Studies show that children who are able to see their parents while they are incarcerated, it helps reduce the emotional trauma associated with losing that parent. Children are less likely to experience kind of fear or loss or abandonment. The behavioral problems that are associated with children whose parents become incarcerated, they have shown to be lessened when they have more contact with that parent.
Sometimes I think we put things in a sort of backwards order. So I've heard people say, well, when the child stabilizes in the foster home, that's when we're going to take him to see mom in prison. But that child may be not stabilizing in the foster home because they need to see mom in prison now.
It also, and this is not a small thing, recidivism rates for parents who maintain contact with their children while they're incarcerated is lower. Right? Parents are less likely to end back up in the system. They're more likely to have successful reentry when they have and maintain relationships with their children. Because even though I think the court system does not like to think this is the reason parents do well in life, they are motivated by their children. And anybody who works with parents will see that, parents want to be better, do better in life for their children all the time.
Court-appointed special advocates can be assigned by judges and referees, and in New York City, court-appointed special advocates specifically developed a project called Project Family Connect, or PFC, that focuses on ensuring that the needs of children who are in the child welfare system and have a parent who's incarcerated, that their needs are being met. CASA and Project Family Connect provides reports to the court at family court appearances. So CASA can provide information that's helpful and critical to helping judges and referees with the decision-making process. Also in assisting caseworkers with locating where a parent is in the correctional system, helping to track that parent's whereabouts. For example, if the parent is moved from facility to facility and has a difficult time communicating that to the foster care agency. PFC can also work with both the caseworker and the family to arrange for visitation between the parent and child, and can establish communication with the correctional facility. So, for example, the ORC or offender rehabilitation counselor at the facility to, for example, obtain information regarding programs available to a parent, advocate for a parent to be able to participate in programs, or obtain information on specific visiting guidelines at a facility. Another area that PFC can be very helpful is linking an incarcerated parent with reentry services, pre-release and post-release, to help facilitate the return to the community and to also help to support the parent as the parent prepares to reunify with the children in the community.
One important role for a family court judge is to make sure that all the parties are talking to each other and planning together. One of the unfortunate facts about family court is that the attorneys often go their own separate ways and don't communicate until they're in court. A family court judge needs to make sure that the foster care agency caseworker is fully informed about the incarcerated parent's programs that are available to the parent in prison, the relationship that the child and the parent have, and to keep all of the other parties informed of this. The family court judge also has a responsibility to make sure that the parent's attorney is maintaining regular contact with the parent and is fully informed of the parent's situation, and that the parent's attorney is working with the attorney for the child, and the two of them are sharing information. A family court judge, in addition to presiding over a case, is really somebody who has to manage the flow of information and make sure that that all of the parties are really working in harmony to come up with a plan that will best serve the family's needs. It's important for family court judges to educate themselves not just about prison generally and about the sentencing structure and about what's possible in prison, but to get to understand who this parent before him or her is. In the same way that a judge would do that with any parent, to try to understand as much as possible how long the parent will be in prison, what kind of contact the parent is able to have with the child, how the child feels about the relationship with the parent, what other family supports there are. These are all very important considerations. They're time-consuming, they're difficult, but that's the work that family court judges need to do. And the expanded discretion law, I think, helps make that more manageable for family court judges.